Good evening, everyone.
Good evening.
Welcome. My name is Dave Vorvek. I'm the pastor here at St. Martin's Lutheran Church, and I have the distinct honor of welcoming all of you and thanking you for coming out to this special event. We're blessed to host this event for a bunch of different reasons. One is because we have the opportunity to extend hospitality to our neighborhood and our community. And I'm a firm believer that whenever good people get together and share in some kind of an experience, that good things come from that. And so to have the opportunity to share a meal together and just some time together and a stimulating lecture to come, that's good stuff. So we're glad to be a part of that. It also gives us a platform to say thanks for those of you who are in the community doing good work, but specifically the men and women who wear the cloth of our community, if you will. Some of them are in blue, some of them are plain clothes, but day in and day out, you guys are out there, and gals, are out there making our community stronger, better, more loving, safer, and that is appreciated, and I hope you hear that a lot. Certainly we feel that way towards you. And also along those same lines, we're glad to host this because we get to hear from the guy who has been called upon to lead the charge on all those fronts. So Chief Ed Jackson is here to share with us this evening, and he wears many hats. As the lead enforcer, as the lead bridge builder, as an encourager, as a gatherer of people, so many different things. But from our brief time together, I'm thankful for you, and I appreciate the opportunity to share a bit of introduction about our chief. So I wanted to share some bio information, and then I will hand the baton to him. Chief Edward C. Jackson began his career as an officer with Baltimore Police Department in 1983, moving up the ranks from police officer in 1983 to colonel in 2004. Wow. He has been a program director and assistant professor in the criminal justice program at Baltimore City Community College. In 2018, he was rehired by the Baltimore Police Department as Chief Office of the Inspector General to provide agency-wide oversight of administrative and operational practices for the Baltimore Police Department. He served as a member on the Community Oversight Task Force, charged with making recommendations for strengthening police accountability and police community relations in Baltimore City. He is a PhD candidate at Capella University, where he is completing his dissertation. He has a Master of Science in Applied Behavioral Sciences from Johns Hopkins University and a Bachelor of Science in Criminal Justice from Coppin State University. He was appointed Chief of Police on July 31st in the year of our Lord 2019. Chief Jackson, we welcome you.
Thank you.
And we thank you for what you do and for what you're about to share.
Thank you so much, Pastor. Thank you to St. Martin's Church, Lutheran Church, for having us here tonight. Before I get started, I'm going to ask all of my staff to stand. That's just the quickest way to do it. I see my captains here, my lieutenants. And so they came out, my cadets, my secretary. I'm the type of speaker that once I get going, then I'll probably move around. So if you will, Sarge, if you'll make sure I don't get in front of everything. Okay, thank you. You want to do it? Yeah, you want to do it down?
Yeah, if you would.
Yes.
Okay.
You would want to do it now? Sure. Pastor Dave, can you come up for a minute? Yes, before I get started, I'd like to make a presentation. It's from the Annapolis Police Department, and it reads, "For your support and participation in the Chief's Lecture Series, St. Martin's Lutheran Church," and it's signed by me, dated today's date.
Awesome.
And we are like, all your challenge corn too. We also like to give you an Annapolis mug. So
Good. Thank you very much. Appreciate that. Thanks, Patty. Thank you very much.
Thank you.
Yeah, I will share this with the congregation, and I won't share this with the...
Thank you, sir. I appreciate you. Okay, we're going to get started. This is where the rubber meets the road. We're living in some challenging times. Just by a show of hands, I'm going to make this interactive, and then I want to save some time so that we can have a Q&A, because I believe that the most interesting lectures are the ones that are engaging, and the people who are taking the time out of their busy schedules to come here, which I thank you for very much. I think it means more when you can say that you've participated. So having said that, we can start. I just like that. I always like our American symbol for a lot of reasons. If you know American history, teach you in school. I think Benjamin Franklin wanted the turkey, and he was overruled. And the eagle, of course, it's a vulture, but it's strength. And two things I want to point out. That's what I love about at least where we are on paper in America. You have the olive branch here, right? Symbolic of peace. But then we have the arrows here, right? And that's kind of like a tribute to our great military that will defend vigorously our democracy and all that's true to our beliefs, and we're willing to defend it. And of course, we honor the men and women who've made the ultimate sacrifice to ensure that our democracy remains intact. So it's this, and other symbols, of course, the stars or the 13 colonies, the 13 stripes, and then, e pluribus unum, out of many, one, e pluribus unum, the Latin, out of many, one, plurus, plural, and unum, one, so out of many, one. So I just love that symbol. It has nothing to do with my presentation. I just throw it in there because it's part of America. So having said that, the purpose, and I wrote this this afternoon. I said I need a purpose. The purpose of this lecture is to engage the community in a presentation, then dialogue about the highest source of law in America, the United States Constitution. We're living in very challenging times as many traditional values are being redefined and are rapidly changing. Law enforcement, the courts, and our legislatures at the state level, as well as our U.S. Congress, are struggling to keep pace with the rapid emergence and redefining of our cultural norms. New demands for civil rights and changes to the way we as a society approach solutions to problems such as police brutality and excessive force make it more important than ever that everyday American citizens be made aware of their rights under the Bill of Rights and the limitations and barriers that the Constitution places on police. As we strive to strengthen our relationship with the community, an understanding and constant dialogue about the criminal justice system in general and policing in particular is imperative to fostering public confidence and support. So that's pretty much the purpose. I get frustrated when I hear the misinformation out there, what the police should be doing and what they shouldn't be doing, what they can do and what they cannot do. We get all of our authority from the United States Constitution. Now, before we get started, I'm gonna lay the foundation. We get our sources, our law from four sources, basically four sources. American law comes from four sources. And I highlighted the red because that's the highest form. They're in the order. That's the pecking order. The first, of course, is our United States Constitution. The second is case law. That's appellate court decisions made by judges, and we'll talk about that a little later. The third is law enacted by the legislature. The legislature being we have 50 legislatures, right? State legislatures, and then we have one federal legislature, and that's our U.S. Congress. Everybody still with me? And then the fourth one is administrative law. That's that law, that regulatory law, the Environmental Protection Agency. What's another one? Say that again? IRS. The Internal Revenue Service. What's another one? The Federal Aviation Administration, right? The FCC, the Federal Communications Commission. What's another one? One more. The EPA, the Environmental Protection Agency. And that's the source of law that protects the American citizens against unscrupulous practices from industry and in the workplace. Because we all know that some people, in the interest of making a dollar, would do anything. They would put things, the FDA, Food and Drug Administration, how many times you watched the news and you've heard about companies putting things on our shelves in our supermarkets and in our pharmacies that do more harm than good? Everybody with me? And so that source of American law regulates that. So I want you to remember this. Of the four sources, the highest is the U.S. Constitution. Second highest are our case law and appellate court decisions. Of course, appellate court decisions, what's the highest appellate court in America? The United States Supreme Court, very good. And our state appellate courts, and law enacted by the legislature and administrative law, very good. Now, an understanding and history of our Constitution is crucial to understanding our democracy and why law enforcement exists and where our authority to operate originated and where we are currently at today. And by the way, before I even go any further, this whole presentation is primarily about your police department, why we operate the way we do, to dispel some of the misinformation that's been put out there. The toughest job that a policeman has is to remain objective. And as you well know, I'm a man of color. We just named the Annapolis Police Building after the first African-American police chief, Joseph S. Johnson, today. Very nice ceremony. He served 16 years as the chief of police for the city of Annapolis, one of the most tenured police chiefs in the history of Annapolis, which dates back to 1867. And so standing here as a man of color, I know the history of America, I know its greatness and its shortcomings. But when I pin on this badge and I raised my right hand and took the oath to be a police chief, I'm a police chief to what? All Annapolitans, all citizens, regardless of what? Race, creed, color, ethnicity, religion. So I have to be the police chief, and I believe in the Constitution. I support our Constitution. I believe in America. You won't find any civilization that hasn't had its shortcomings. I have meetings all the time where we talk about the problems of Annapolis in certain areas. We talk about the problems in Baltimore and cities like Baltimore. You name them, New York, Philadelphia, Los Angeles, Chicago, Charleston, South Carolina. They all have problems, and many of these problems are really social problems that police are really ill-equipped, in my opinion, to deal with. But yet, we have to deal with the result of those social problems being unaddressed. Everybody's still with me. I mean, and I'll just throw this in here before I go in any further. There are 6 institutions of social control in our society, and I'll say this everywhere I go, and I just want to, for those of you who haven't heard this yet, it's my theory that we have 6 important institutions of social control. The first 3, I would argue, is the family, our schools, and our faith-based institutions. When they fail to get you to subscribe to the dominant values of society, and if you can't comply with those morals that we expect you to abide by, then the other 3 generally are prevalent in one's life, and that's police, courts, and corrections. So my argument is that you would rather have family, our educational system, and our faith-based institutions to get you to subscribe to the dominant values of society than the police, courts, and corrections. By the time police, courts, and corrections get involved, something's gone terribly wrong in the community. Everybody with me? Does that make sense? Any comments? Okay, having said that, now, terms to remember. And these are terms I came up with. There are far more. The Constitution is about 10,000 words, about 26 pages. I just love it. I think it's one of the most, and I shared with the pastor while we were having spaghetti, I said it's one of the most prolific documents ever written. The problem is that so many people misunderstand it, that a lot of the social problems that we have are perpetuated, and in some instances are enhanced by our lack of understanding of the Constitution. And so if it's explained right, and I'm a kind of folksy type guy. I believe in connecting with people, and I love to share knowledge. As I get it, I can't wait to pass it on. And I think that that's part of the problem with many of our institutions. What the police do every day shouldn't be a mystery to our citizens. This badge belongs to the city of Annapolis. This uniform belongs to the city of Annapolis. Everything about what I do when I come on duty belongs to the citizens of Annapolis. So it makes no sense to me that if this belongs to the citizens, that we operate in secret and our citizens don't know what we do. If they know what we do, they can become better advocates, for us? Does that make sense? Yeah. But you can't advocate for something that you don't understand, right? So you have to understand it in order to advocate for it. So now, these are some of the terms that I'm going to talk about. The Constitution has 3 component parts, and if you look at the top, can you hear me? Yeah. Yes, this is the preamble, and I'm going to get to that in a minute. That just tells what the document's going to be about. That's the first component part. Then the articles. There are 7 important articles, and I'll explain that. And then the amendments, Those are the three component parts to the Constitution. And the Constitution has been amended how many times? How many times, my cadets? I want y'all to write this down, my cadets, right? They're still in college, right? How many times? 27, very good. 27, that's my school teacher. Yes, 27, right? 27 times it's been amended. The last time it was amended in 1992. It's about 28 years ago. And I'll talk about that. Now, how many read the paper the last week? Last Monday, I think it was, I went to a meeting, and I'm not going to back down from this at the Eastport Civic Association. And I was asked the question, hey, Chief, how do you feel? And the meeting was about the violence in Harbor House and the recent spate of shootings. And I was asked the question at the meeting, how do you feel about stop and frisk? And I said, oh boy, it doesn't sound like a trick question. I said, as a policeman, yeah, I support it. I said, I support it because the Supreme Court and the decision of Terry versus Ohio. Remember, we just talked about the four sources of American law, right? I said that the second one was case law. Terry versus Ohio was handed down by the Supreme Court in 1968, right? And what it did was it allowed police officers, what happened, it was the 9 justices, this was the Warren Court, kind of lowered the threshold, and I'll get into that a little bit later, lowered the threshold from probable cause to reasonable articulable suspicion. Before 1968, cops had to pretty much get a warrant for everything. But if somebody's on Main Street getting ready to walk into the jewelry store, armed with a semi-automatic handgun, we don't have time, right? Lieutenant Krause to run to Calvert Street and see a magistrate. He's held up the entire Main Street, all the way up to Church Circle, right? So you have to be able to act now based on RAS. And what is RAS? Reasonable articulable suspicion, right? Reasonable is a compound word, right? Reason and able. Reason is the noun, able is the verb. You put them together, you have reason, able, reasonable, right? And so as long as you can give good reason as to why you did what you did, then the Supreme Court lowered the bar and the Warren Court. And if you talk about the criminal justice process, you have crime control and you have the crime control and you have due process models. There's 2 models to the criminal justice process is what I'm trying to say. And you have 2 models, crime control and due process. The Warren Court was a very liberal court, right? Chief Earl Warren himself was very conservative, former California governor, but once he got on the court, he made rulings that we couldn't have imagined. In the 1960s, during the time that the Terry decision was handed down by the United States Supreme Court, the United States had never seen the Supreme Court operate in the fashion that it did. It's commonly referred to by historians as the due process revolution, where numerous rights were given to American citizens. But the court did something interesting. Instead of probable cause, they amended the Constitution to say reasonable articulable suspicion when police officers encountered people who they believed posed an immediate threat. And what it did, it gave them the authority. Can you stand up for me for 1 second? I'm kind of getting ahead of myself. I need a microphone. What it did, if I was to see Stan, can everybody hear me? If I was to see Stan walking down the street and I could articulate that he was up to no good, right? And the Supreme Court gave me the authority as a law enforcement officer. If I saw something sticking out of his waistband, I could say, hey, hold up. Where are you going? I can ask him certain questions. Where are you going? Where are you coming from? What's that in your pocket? And if it looks like a gun, then the Supreme Court said in the Terry case that I can do what? Pat down what? The outer layer of his clothing. It didn't say I can go inside. Remember the term I used, reasonable articulable suspicion, right? This is the reasonable articulable suspicion. The fact that he's headed towards a jewelry store, he's with some guys, one of them I may know to be engaged in criminal activity. It's imminent, the threat is very imminent, meaning it's going to happen very soon. And so the Supreme Court said invariably, you can stop him to ensure the public safety, to make sure he's not armed. So I'm allowed to pat down the outer layer of his garments. Now say I find something and I feel it, and I said, this is the butt of a gun. Now I've gone from what? Reasonable articulable suspicion to what? Probable cause in a matter of what, Kelly? Seconds, right? I'm going from reasonable articulable suspicion to probable cause in a matter of seconds. Now I have probable cause to do what? Search. You have probable cause to do two things according to the Constitution. Probable cause to search and probable cause to do what? Seize. Now, I've done both in this case, right? I've actually seized Stan. He's not free to go, so I've seized him. And we'll talk about that in a minute. Now, I'm doing a full-blown search. I have probable cause. I pull out the object. It turns out to be a semi-automatic Glock. He doesn't have a permit or authority to do what? To carry it, right? Then the Supreme Court says after I secure the weapon, I can go into what? Enforcement mode. Get him up. Get him up, right? Lock his hands in, right? Make sure he doesn't have any other weapons, and then take him and do what? And put the handcuffs on him, right? Thank you, Stan. I didn't hurt you, did I? No. Oh, okay. So when I was asked this question last week, they said stop and frisk. Isn't that stuff that Mayor Bloomberg did, Michael Bloomberg in New York, that violated the rights of all those people? And when I answered that question, they asked me was stop and frisk, did I support it? I support it based on the scenario I just gave. And I said my response was, as long as it's done constitutionally. I said, but I can't develop a policy or a system that would allow the men and women who so bravely put on a uniform every day to go out there and potentially get gunned down, because there's always two sides of the story. We talk about police brutality, and I'm not here to stand up here to say it doesn't exist. We talk about police misconduct. I'm not here to say that doesn't exist. When it does exist, we need to deal with it promptly and swiftly. We need to inform the community, and then we need to move on. But we have to have what? Public safety. So I can't adopt a policy that would put my officers in harm's way. So if I have somebody potentially doing harm, because we take an oath to protect what? Our citizens, and we have a duty to do what? Protect ourselves and each other. Everybody still with me? And so as long as it's done constitutional, what I said in that response to that answer, and it took that long to answer, didn't it, Stan? I said what I don't support is racial profiling. I don't support you targeting a person or picking out a person randomly just because of their color, their skin, or their ethnicity. Then yes, the citizens have an absolute right to be outraged. But at the end of the day, no matter how much we deal with social problems and work with groups to try to work through neighborhoods and communities that have been underserved and have been left out, we still have an obligation to do what? Protect everybody in here. So everybody expects to leave here tonight and go home. If they're met with a threat, then that's what you hire a police force to do, is to protect you and your family against threats. And so in that context, I support stop and frisk. Does that clear it up? Not that anybody in here needs clearing, but that was the response that I gave last week. And so what happens if the narrative is framed inappropriately, then that becomes people's reality. And what I don't want my officers to do is to be tentative if they see a threat and not exercise what the Supreme Court says that we have the authority to do under Terry v. Ohio. Oh, let me go through a few more. We're going to talk about probable cause. Another good one is the particularity clause. I already mentioned reasonable articulable suspicion. And there is a distinct difference between the Terry stop and stop and frisk. Then we're going to talk about the Fourth Amendment, a suppression hearing. We're going to talk about the exclusionary rule. I'll touch on fruits of the poisonous tree doctrine, which is rooted in the Old Testament of the Holy Scriptures, right? We all know the story, the poisonous fruit. We're going to talk about search and seizure, due process of law, the 14th Amendment, and the Fifth Amendment. Case precedent, the Latin calls it stare decisis, right, for my lawyers in here. Let the previous decision stand, right? And then we're going to talk about self-incrimination. You know, when we interrogate, every citizen in this country can do what? Invoke the what? The right to remain silent. The government can't force you to be a witness against what? Yourself, right? So you can say, not that I pray the Fourth Amendment, I invoke the Fourth Amendment, right? I plead the Fourth. You don't plead the Fourth, you invoke it. You plead not guilty, right? And you invoke the Fourth, right? Or the Fifth. I'm sorry, the Fifth. The Fifth. I'm sorry, thank you. Good to see you. The Fifth. And that guards against self-incrimination. That's just a fancy way of saying that the government can't force you to be a witness against yourself. And then apportionment, I'm going to talk about that, apportionment. And apportionment is the distribution based on population. And the 3/5 compromise. Anybody ever heard that black people were written as 3/5 of a person in the Constitution? We're going to dispel that myth too. How many people know that's a myth? There's no such thing as 3/5 of a person, right? Stan's a bigger guy than me, no offense, but he's a bigger guy than me. He weighs more. So 3/5 of me is different than 3/5 of what, Stan? And I'll explain that. So these are the terms to remember. Now, here's some famous case law handed down by the Supreme Court. These are all Supreme Court decisions. They're state appellate court decisions as well, but these are all United States Supreme Court decisions. Of course, I talked about Terry versus Ohio. Another good one is Weeks versus U.S., Mapp v. Ohio, Curl versus U.S., and one that's really particular that I have to mention if I have the time tonight is Tennessee versus Gardner. That deals with seizure, right? It's a very interesting case, and I'll try to talk about that a little bit. And then another one, case law surrounding the Fifth Amendment, right? Miranda versus Arizona. What is Miranda versus Arizona? The rights. I call it that sexy rights, right? You have a right to remain silent. If you give up that right to remain silent, anything you say can and will be used against you in a court of law. You have a right to an attorney. If you can't afford an attorney, one will be appointed to you. That if any time during questioning you refuse to answer any other questions, no further questions will be answered of you. Do you understand your rights? And we're going to talk about Ernesto Miranda and the Arizona case. It's out of a Phoenix case, and it dealt with a Latino immigrant. And so he was charged with kidnapping and rape. And they kind of coerced him into being a witness of what? Against himself. And he was convicted in the state of Arizona, but the U.S. Supreme Court, again, during the due process revolution of the 1960s, and most of us in here weren't born in the 1960s. I'm looking at a few gray-haired people who were here during the 1960s, during the psychedelic movement, the civil rights movement, Dr. King, and the Kennedy's brothers, Bobby, President Kennedy and his brother Bobby, Martin Luther King, and all these case law that are still in existence today took place during the due process revolution when America was going through what? A civil rights revolution. And then another interesting case is Gideon versus Wainwright. That's a Florida case where a gentleman really represented himself. He asked for a lawyer, and he went against the all-powerful government that's called prosecutors, right? I mean, I know that I love crime stories, and I love crime history, and I'd rather have the mob after me than the U.S. government. Reverend Colbert, they never run out of resources, right? At the U.S. Attorney's Office, once they get on you, they never run out of resources. I'd rather have the mob. You can hide from the mob. You can't hide from the federal government. So once they get on you, and Gideon represented himself. Very indigent. He was accused of burglary. He represented himself. And then the Supreme Court says, wait a minute, that's kind of imbalanced. You know, he was semi-literate, and he didn't give a very good defense. Nothing good was going to come out of it because he represented himself. Oliver Wendell Holmes says that a person who has themselves represent themselves has a fool for a client. And so Gideon versus Wainwright lends to that. So we'll talk about that a little bit as we go forward, move forward. Any questions so far? Any questions? Okay, now I'm going to get into the three component parts of the Constitution. This is the part I like. We the people. And what I love about the Constitution, it almost equates past to like the Bible, that the words were so carefully crafted that most of the words are symbolic of something. Now, we know that many people get the Declaration of Independence confused with what? The United States Constitution. One declared our independence from the crown, right? From the British powers, right? And so I'll get into that some other time, and I'm no expert on the Declaration of Independence, but I kind of know what it's about. But the Constitution is different. By this time in 1789, we all know we celebrate the 4th of July. We gained our independence theoretically on July, 4th, 1776. By 1789, when the Constitution was ratified, now it establishes the government as we know it in 2020 to this day. Not much has changed when we get into the framework of the Constitution. And as we go through this, I'm going to very, very methodically lead up and have a heated discussion about the Constitution and policing. So now, we the people, that means everybody in this room, right, of the United States, in order to do what? Form a more perfect union, right? Our government, establish justice and ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our what? Posterity. What does posterity mean, my cadets? My cadets. What does posterity mean? Oh. See, that's why we have cadets, right? We're gonna social them to ourselves and our posterity. Posterity comes from the word post. That means after, for future generations, right? To ourselves and our posterity, right? That means that generation, they wrote this document, they anticipated being able to be enforced or sustain itself through future generations, right? And so it says, for ourselves and our posterity, do ordain and establish this Constitution for the what? United States of America. And that's the preamble. That's one important component part. But what I like about it says for ourselves, the times they were living in, and future, our posterity, future generations. Now, 7 articles, and then we don't have to go through all of them, but there's 7 articles, but I'll go through the ones that I thought are important. It says, Article 1, legislative. All legislative powers herein granted shall be vested in the Congress of the United States, which shall consist of a Senate and a House of Representatives, kind of based on Parliament. And the reason why they had 2 houses, it's called a bicameral system. Bi meaning 2, cameral meaning house, 2-house system. They could have had 1. I believe personally, in my study of the Constitution, they wanted 2 because, again, we talked about apportionment, right? We are in 2020 now, and we're about to do something. What's going to happen this year? The Census Bureau. We talk about that in the Constitution, right? The Census Bureau. And in the House of Representatives, the amount of representation you send to the Congress is dependent on what? The population that you report. Everybody with me? And then that ties into the 3/5 compromise, but we'll talk about that in a few minutes. Now, it says a Senate and a House. In the Senate, though, let's go back one second, if you don't mind going back, and I won't be long on this. But we have a Senate. What's the difference between the Senate? We know the House is based on, the House of Representatives is based on this idea of apportionment, right? Meaning that the number of people you send is based on the population. But the Senate, regardless of the size of the state, you still have how many senators? 2, a junior senator and a senior senator. It's common sense. The senior senator's been there the longest. Some states have 2 senators that's been there. One's been there 50 years. The other one's been there 60 years. So when you hear the word junior senator, he's not junior to Congress. So he's just been there a little less, or a lot less than his colleague. So regardless of the state, I think Alaska sends 1 person to the House of Representatives, maybe 1 or 2. Hawaii is even worse. I think they send 1, but they both have what? 2 United States senators. Everybody with me? Okay, you can move it forward. Now, Section 2, the House of Representatives shall be composed of members chosen every 2nd year by the people of the several states, and the electors in each state shall have the qualifications requisite for electors of the most numerous branches of the state legislature. No person shall be a representative, and here's the part that I'll just harp on. I can go on all day, but in the interest of time, no person shall be a representative who has not attained the age of what? 25. So that still exists to this day. In order for you to serve in the House of Representatives, you have to, amongst other things, the age requirement is that you be at least 25. You've reached your 25th birthday. And have been a citizen how long? 7 years of the United States. And who shall not, when elected, be an inhabitant of that state in which he shall be chosen. Meaning you have to live in the state that you what? Represent, right? Says the House of Representatives, right, shall choose their speaker and other officers, and shall have the sole power of impeachment. So we just had a president impeached, right? What's his name? Donald Trump. We've had 3 presidents impeached in the history of America. We had Andrew Johnson impeached, right? About 140 years ago, maybe a little longer, about 160 years ago. We had Andrew Johnson. Then we had my man impeached in the early 1990s, and that was what? William Jefferson Clinton, right? And then, of course, most recently we had President Donald Trump, who was impeached. Now, an impeachment is equivalent to an indictment. It doesn't automatically remove you from office. How many people thought that impeachment automatically removes you from office? Okay. Yes, no. An impeachment, of course, we know that now from the Donald Trump impeachment trial, right? The House of Representatives, they draw up the charges, right? The Speaker announced it. And who's the Speaker of the House? Nancy Pelosi, Baltimore lady, right? Her brother was mayor and her dad was mayor, right? I used to live right on the same street as Nancy Pelosi. I live in the public housing side, and she lived in Little Italy, but the same street. Growing up in southeast Baltimore. I have a picture, one of my favorite pictures in my photo album. He just passed away. It's me as a 12-year-old giving a speech to Mayor Tommy D'Alessandro III. And that was in 1968, I think. I was about 9 years old. And I'm wearing this loud yellow jacket and then some bell-bottom pants. It was the 1960s, and I had an afro that my mother let me grow out. That was around the time Michael Jackson came on the scene. Everybody wanted to be Michael Jackson in those days. The House of Representatives shall choose their speaker and other officers and shall have the sole power of impeachment. The charges are drawn up in the House of Representatives, but the case is actually tried where? In the United States Senate. Okay, you can advance it. I just want to talk about the Senate. The Senate of the United States shall be composed of 2 senators from each state, regardless of population, by the legislature thereof for 6 years, and each senator will have 1 vote, right? Now, what is the vice president's role? What's an important role that the vice president has? President of the Senate. Right, he is the president of the Senate, right? And in his absence, they have the president pro tempore, right? And that's somebody who actually serves in the Senate. But when the vice president's not there, and basically his job is, this has been a very historic president. Whatever you think about President Trump, and as being in uniform, I have no opinion about President Trump. Now, you catch me in my living room, I can give you an earful. And you may be surprised at some things and not the other. But as long as I'm in uniform, he's our president, and I support him. And if he walked in this room now, I would salute him, because that's what cops do, good cops do. But getting back to the United States Senate, they serve 6 years, and they shall have 1 vote. They are charged with actually listening to the evidence, and they make the determination whether the president is going to be removed in office based on whether he's found guilty or not guilty on whatever articles. I think President Trump had 3 articles of impeachment, I think. And he was found not guilty in all 3. But getting back to the president, he has an important role, because in the absence, if there's a tie, it's 100 senators, right? So theoretically, you can have a 50-50 tie. Who casts the deciding vote? The vice president. That's one of his important duties, and waiting for something to happen to the president so he can assume the office, which we hope never will happen. Of course, in my lifetime, it happened on November 22nd, 1963 in Dallas, Texas. I was a little boy when President John Kennedy was assassinated, and Lyndon Baines Johnson had to assume the office of the presidency. I hope that never happens again. Let's see. And some things have changed now. If you see, I highlighted in red letters, the vacancies happen by resignation. This is still the Senate I'm talking about. During the recess of the legislature of any state, the executive thereof may make a temporary appointments. That still exists, meeting the legislature, which shall then fill such vacancies. The only difference now, senators are elected by the people, where 70 years ago, I think around World War II, the governor still appointed members to the United States Senate. Now they're part of the general election. Then it says, no person, number 3, no person shall be a senator, who shall not have attained the age of what? 30 years old, and have been, 9 years a citizen of the United States, and who shall not, when elected, be an inhabitant of the state for which he shall be chosen. Now, what's interesting about that, everybody's heard of Joe Biden, right? I met him in 2005, and I was amazed at how handsome a guy he is. Joe Biden, our former vice president under President Barack Obama. I met him in Louisville, Kentucky, and he comes in, and a very folksy guy. He made sure he shook everybody's hand who was sitting on the end of the aisle. And by chance, I happened to be sitting on the end of the aisle, so I got to shake. And he wasn't vice president, he was Senator Biden. But he said something interesting. He talked about his career and his life, and he's had a very tragic life. In 1972, his wife was killed in a car accident, and his son, while they were doing Christmas shopping, the son was severely injured. And of course, he lost his son, Bo, a few years ago, who was the Attorney General for the state of Delaware, and had served in Afghanistan as a high-ranking military officer. So he had a very tragic life. But something interesting about Joe Biden, the citizens of Delaware elected him to the Senate when he was 29 years old. So he had to wait to his 30th birthday constitutionally before he could take the seat. That's a true story. He was too young to take the seat, so he had to wait a year before he could assume his Senate seat. And he's been there ever since. It's hard to believe that Joe Biden was ever 29 years old. That's another story. The Vice President of the United States shall be the President of the what? Senate, but have no vote unless what? they be equally divided. The Senate shall choose their officers just like the House of Representatives, and it says that the Senate shall have the sole power to do what? Try all impeachments. Who can be impeached? The President, the Supreme Court Justice, any high-ranking, it's not only the President that can be impeached, right? Federal judges can be impeached. Supreme Court justices can be impeached. They're lifetime appointments, but if they commit high crimes and misdemeanors, they're subject to the same process as the President. Did you learn anything? And so it says that the Chief Justice of the Supreme Court shall do what? Preside over any impeachment trials, right? And then it says judgment in cases of impeachment shall not extend further than the removal from the office. So, ladies and gentlemen, if impeachment occurs and they find the president guilty on the articles and determine that he has to be removed from office, there's no appeal process, immediately there's a transition of what? Power. And then the vice president becomes president of the United States. We just finished with the legislative part of it, the United States Senate and the House of Representatives. In the interest of time, I want to speed it up to Article 2. And that's the executive power shall be vested in what? The president, right? Because we have 7 articles, and the 7 articles are about individual rights, right? It's about the separation of powers, and it's about how our government's going to be structured. And that's the basic premise of the entire Constitution. So I'll read this real quick. The executive power shall be vested in the President of the United States of America. He, or one day she, shall hold his office during the term of 4 years, and together with the vice president chosen for the same term, be elected as follows. Each state shall appoint in such a manner as the legislature thereof may direct the number of electors. And I'm going to stop right there. We have a popular vote and we have an electoral college, right? Each state has electors. And again, the number of people, that's why the Census Bureau is so important. And the data collected in the Census Bureau is so important because the number of people, for example, Maryland has, is it 8 congressional districts? Right, we have 8 congressional districts. And we have, 8 congressional districts. And how many senators do we have? 2. So how many electors do we have? We have 10. We have 10. And the 10 represents the 8 congressional districts. And of course, everybody gets a minimum of 2 because each state gets 2 senators. Here's the qualifications of the president. No person except a natural born citizen or citizens of the United States at the time of adoption of this Constitution shall be eligible to the office of the president. Neither shall any person be eligible to that office who has not attained the age of 35 and been a citizen for what? 14 years. So in order to be the president, you have to be natural born, not naturalized, but natural born, and have to have attained the age of 35 and been in the United States for 14 years. And of course, we just talked about that. In case the removal of the president from office, or his death or resignation. We had one president to resign in the history of our country. Who was that? Nixon. Richard Milhous Nixon resigned in 1974 ahead of his impeachment, right? That's another story. The Watergate scandal, yes ma'am, that's exactly right. So in case of removal of the president from office or his death, and we've had Franklin Delano Roosevelt, right? He died in office, and Harry Truman assumed the office during World War II, right? So in case of removal of the president from office or his death, resignation, or inability to discharge the powers and duties of said office, the same will devolve on the vice president, meaning that it automatically goes to the vice president. And that's what the vice president is there for, to make sure that the transition of power is a smooth one. You can advance it. And the president, according to the Constitution, and I'll just kind of paraphrase this, he has about 6 basic powers, he or she. Has the power to appoint, right? I mean, all the Supreme Court justices, if there's a vacancy, he appoints a Supreme Court nominee, and of course confirmed by the Senate Judiciary Committee. He can enter into treaties with other countries, right? We know that he can dispatch the Marines anywhere in the world, right, without going through Congress or declaring war. So he has the power to veto, right, any bill. Of course, the Congress's rebuttal to that, they can override, right, and his veto. So the president only has about six basic powers. Where he becomes so powerful is the president is a big celebrity. He holds the highest office in America, which invariably makes him the most powerful office holder in the world. So if I want to sell tickets to come to my fundraiser and I can get Donald Trump there, instead of charging $40, I can charge $1,000 and guarantee you my $1,000 donors can get to shake his hand and take a picture with him, right? And so that's why that's where the politics come in, right? But the actual powers, he doesn't have that many. He shall give from time to time to the Congress information of the State of the Union, right? So that's not anything that NBC News just calls for, right? The Constitution says that at any time, right, he gets in touch with the Speaker of the House and he says, I want to have a State of the Union. He can call both, another one of his duties that he can hold a joint session of Congress, right? The President has the power at any time to call the House of Representatives and the Senate together. So it says he shall from time to time give the Congress information of the State of the Union and recommend to their consideration such measures as he shall judge necessary and expedient. And he may, on extraordinary occasions, convene both what? Houses. I just said that, right? Or either of them in the case of disagreement between them with respect to the time of adjournment. He may adjourn them to such time as he shall think proper. He shall receive ambassadors and other public ministers. He shall take care that the laws be faithfully executed. That's why he's in the executive branch, right? It's his job to do what? Enforce the law. Again, this is directly from the Constitution. And it says the president and the vice president and all civil officers of the United States shall be removed from office on impeachment for conviction of what? Treason, bribery, and other high crimes and misdemeanors. The Constitution only recognizes one crime. That's it. And what's the crime? Treason. That's the only crime that the United States Constitution recognizes. Okay, Article 3. Now, we've gone over the legislative part of it. We've gone over the executive. Now, Article 3 is the judicial power, right? The judicial power of the...
I have a question.
Yes, sir.
So Franklin Delano Roosevelt was elected to 3 terms, and he died in office, as we all know. What do the articles say about a 3rd term in general, or multiple terms?
And I believe that after Roosevelt, there had to be amendment. And we'll find that amendment in the 27 amendments that limited his term, the president, to 2 terms, 2 consecutive terms. It doesn't limit him to 2 terms total. A lot of people don't know that. After the president's run 2 terms, he can sit out a term and come back. Nobody's ever done it since Roosevelt. After Roosevelt, you can no longer run until you get tired of running. And we'll find that in the amendments. But after Roosevelt, you can only run for 2 consecutive terms. You want to come back later on, like if President Obama want to come back 5 years from now and run again, constitutionally he's eligible.
And is it a requirement of the legislature then to amend that amendment to allow for multiple consecutive terms?
If they wanted to do it again, yep, they would have to amend that. Not only our Congress, but we have to get 2/3 from the states too. Whenever the Constitution is amended, it requires approval from both all 50 state legislatures and our Congress, both. Yes, sir. The judicial power of the United States shall be vested in one Supreme Court, right? Supreme means above, right? And such inferior courts as the Congress may from time to time ordain and establish. The judges both of the Supreme and inferior courts shall hold their offices during good behavior and shall, at stated times, receive for their services a compensation which shall not be diminished during their continuance in office, right? Once their salary is established, then it's there, right? And we know that we often talk about the Supreme Court, but any court lower than the Supreme Court is referred to in the Constitution as a what? Subordinate court, right? Okay, you can advance it to Section 2. The judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States. Let me say this, that the Supreme Court not only applies to criminal cases, we often think of criminal cases, it also applies to civil cases as well. You have fundamental rights under the United States Constitution when it comes to both criminal cases as well as civil cases. Treason, and some people, if you talk to some people and talk about our current president, some people think that his relationship with Vladimir Putin, did I pronounce it right? Yeah, the Russian premier or president, they call him the president now too. Some people felt that he interfered with our elections. You all know the stories that's aired. Some people believe that he was a little too cozy with foreign governments. And some people think that's tantamount to treason. I'm not here to establish that. How you doing, Alderwoman? Treason against the United States, shall consist only in levying war against them or in adhering to their enemies, giving them aid and comfort. No person shall be convicted of treason unless on the testimony of how many witnesses? 2 witnesses to the same what? Overt act, or on confession in open court, right? The Congress shall have the power to declare the punishment of treason, but no attainder, no bill of attainder of treason shall work corruption of blood or forfeiture except on the life of the person attainted. And what's a bill of attainder? Anybody knows what that is? A bill of attainder, real quickly, is when you are accused of a crime and punished without a trial. And the Supreme Court prohibits that, right? And we can talk about that too. Oh, okay. The Congress, whenever 2/3 of both houses shall deem it necessary, propose what? Amendments. We just talked about that, right? Amendments to this Constitution or on the application of the legislatures of 2/3 of the several states. When they refer in the Constitution of the several states, they're talking about the 50 states today. Of course, back then we had 13 colonies, but they're talking about the 50 states today. Let's see. Let me just take it from the top real quick. The Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution, or on the application of the legislatures of 2/3 of the several states, shall call a convention for proposing amendments, which in either case shall be valid to all intents and purposes as part of the Constitution when ratified by the legislatures of 3/4 of the several states or by conventions in 3/4 thereof, as the one or the other mode of ratification may be proposed by the Congress, provided that no amendment which may be made prior to the year 1808 shall in any manner affect the 1st and 4th clauses in the 9th section of the 1st article, and no state without its consent shall be deprived of its equal suffrage. What's suffrage mean, my cadets? What's the synonym for suffrage? Suffer? Suffrage. To do what? It begins with a V. Women's suffrage. Some say women do suffer, but that's a whole nother conversation for another time. That's another workshop. But suffrage, what does that mean, my young cadets? The voting, right. So equal suffrage in the Senate, that means voting, right. Okay, you can advance it. And basically what that's saying, it requires from both the states and our federal government when the amendment is added to the Constitution. We have 27 so far. If there's an amendment next week, it will require it from both our Congress and our state legislatures. Of course, and it says the test by William Jackson, Secretary, and George Washington, President of the United States, from the great state of Virginia. And we know what my young cadets, what is this plantation called? What is this plantation called? Mount what? Huh? Mount Vernon, right. The very first Mount Vernon outside of the Virginia plantation was where at? In the United States? Baltimore, right. Baltimore. Our Mount Vernon in Baltimore is actually older than the, what do you call it, obelisk? I'm probably pronouncing it wrong, but the old, the obelisk, there you go, in Washington, D.C. Robert Mills was the architect, as a Freemason, and he designed both. The one in Baltimore, right, the Doric column in Baltimore. I'm a Mason, so the Doric column in Baltimore he designed, but he also designed the one in Washington, D.C. But the oldest one, that's what makes Mount Vernon in Baltimore so historic. It was the first monument to George Washington in the United States outside of the actual plantation itself. And then the one in Washington was second. So a little bit of Baltimore history. That's why they called it Charm City when it was charming. That's another subject too. And these are just the people. You know, James McHenry, right? It's a fort maybe named after him. And these are the people. Daniel Carroll. There's a civil rights family. Anybody ever heard of Lily Jackson Carroll? Anybody ever heard of the Mitchell family? Well, one of the signers of the Declaration of Independence was they share blood. That's why her name is Lily Carroll Jackson. I love trivia. I love trivia. Just like, and that's the power of this country and what's interesting in this country. I just love trivia. I was telling you the other day we were riding, and this has nothing to do with this. This will be real short. It's kind of fun when you talk about trivia. Daniel Curl is a part of the Curlton family, which is a prominent African-American family in Baltimore. The first woman lawyer was from that family. It was a civil rights family. Mitchell, the courthouse in Baltimore City, Clarence Mitchell Courthouse is named after him. Well, they are descendants of the Curl family too. And then Jimmy Carter, he's our president of the United States. His mother's maiden name, her name was what? Lillian Carter. If you ever look it up, her maiden name was Lillian Gordy, Gordy. Anybody ever heard of Berry Gordy? Founder of Motown Records, and they were descendants. They were Georgia slaves to the Gordy family, and their family all get together too. And so Berry Gordy, the record mogul, is related to President Jimmy Carter. Interesting, isn't it? And that has nothing to do with the Constitution. This is trivia, though. But I was making a point with the Curl family, so you can advance that. These are just all the signers of the Declaration of Independence. Of course, Ben Franklin, Pennsylvania is the one that's fascinating. So many famous people in Pennsylvania. Okay, now, here's where the rubber meets the road. Here's why I'm here. I just kind of gave an overview, and like I said, the document is 26 pages long, about 9,000 words, the United States Constitution. What I found it so fascinating is that there's just so many things about the Constitution that we don't promote to our children or our community. And if the community is ever going to gain real support for the police, they have to understand what their rights are. I'm not against the community understanding and our children knowing what the police officers should be doing constitutionally and what they shouldn't be doing. Does that make sense? I believe that even beyond tonight, we have to have these conversations. I believe we have some little pocket pamphlets outside. They're not even pamphlets, they're the entire Constitution. So please take one, and there should be extras, and give them to somebody. You can keep them in your purse, you can keep them in your back pocket. For those of us who have blue-collar jobs and wear a sports jacket every day, you can keep it in there with your iPhone. But everybody should study that document. We're living in some perilous times, and know what your rights are. And as your police chief, I plan to have a series of discussions throughout Annapolis. The pastor was so gracious to allow us to start here at St. Martin's, and I'm forever grateful. But we're going to actually take this show on the road, and we're going to be throughout Annapolis, talk about various subjects. And so here's why I'm here. In addition to the articles, we said the preamble, the three component parts, the articles, and the amendments, right? There's 27 amendments. I'm going to focus on some of the first 10. What are the first 10 amendments, my cadets, known as? The Bill of Rights, right? The Bill of Rights. The first 10 amendments, Articles 1 through 10 are known as the Bill of Rights. You can advance it. Okay, article, the first. What's the First Amendment, y'all? Some of this is Schoolhouse Rock from the 70s, right? What's the First Amendment?
Religion, freedom of speech.
Freedom of assembly. How does that affect the police? What do we have in Baltimore? What's the problem in Baltimore? Crime. And then what's crime, right? And what comes on the radar screen, right? We have a former prosecutor. I'm calling her out now, our alderwoman, Rhonda Pendell Charles, the former Baltimore State's attorney. So I have a lawyer in here and a former prosecutor. Remember the loitering? Anybody ever heard of loitering? Some argue the constitutionality of loitering. And loitering is kind of like standing around for the purpose of, for standing around, up to no good. But some argue that you have a right to stand around under the First Amendment, right? Free what? You said it.
Freedom of speech and assembly.
An assembly, right? Freedom of speech. If somebody's in a crowded theater and yell, fire, and then people storm, and that's not protected speech, is it? And why? It creates a danger, it does harm, right? Your speech is protected as long as it what? Doesn't do harm, right? And I'm talking to one of my school teachers who used to teach the Constitution in high school. So, but what about saying that, I don't know, Senator Jones is an idiot? That's protected, isn't it? What about the president? Oh, he's nothing but a reality show star. He didn't go to Harvard or Yale Law School. He didn't graduate Phi Beta Kappa. He wasn't a Rhodes Scholar. He doesn't know about China. He's not an expert on foreign affairs. He's just a joke. And you say that on the TV camera. That's protected, isn't it? Some countries, if you criticize the premier or the president, you'll never be seen again, right? I go over some places in the world and I'm saying that president's an idiot. When the last time you seen Ed Jackson? The last time I saw him, he called the president an idiot, and we haven't seen him ever since. Where do you think he is? He's probably everywhere. He's probably a part of the universe, right? So that's the power of our Constitution, that you do have freedoms. We do have freedoms that other countries don't have. Now, Article 2, here's something, another hot button. The well-regulated militia being necessary to the security of a free state and the right of people to keep and do what? Bear arms shall not be what? Infringed. That's way open to interpretation. Lawyers and scholars have argued for years and years and years what a well-regulated militia means. 1789 is different from 2020, right? I mean, I'm just throwing it out here. The Bloods, the Crips, MS-13, the Black Guerrilla Family, is that a militia? No. Is that a well-regulated militia? Some of them weapons I saw, it looks pretty well-regulated. But constitutionally, is it? No. No. I would argue no, too. You can advance it. Article 3, no soldier shall in time of peace be quartered in any house without the what? Nor in time of war, but in a manner, what? To be prescribed by law, right? You know, I'm a big fan of Westerns, big fan of Westerns. I wake up every Saturday and I can't wait to turn on the TV after I thank God for waking up. And then I turn on Me TV and I start watching all of them, The Rifleman, Big Valley, you know, Bonanza, my favorite. And then you watch those movies from the that take place in the West, right? During I guess that was the period Manifest Destiny. We had the westward expansion in America, and you see these soldiers, Civil War soldiers, that come in and say, put on the beans, and they tell a woman, get in there and cook, and they take over the house. The Constitution protects you against that, right? We're tarred, my horses are tarred, and they bully these people and take it over their property, right? So that's the best example I can give, but it prohibits that. It has to be more structured. Now, here's where the rubber meets the road, the Fourth Amendment. I've studied the Fourth Amendment for probably about 30 years of my life professionally because it is at the core of what police do. And so I'll read this slowly. The right of the people to be secure in their persons, houses, papers, and effects against what? Unreasonable searches and seizures shall not be what? Violated. And no warrant shall be issued what? But upon probable cause. Supported by what? Oath or affirmation. And then what? Particularly what? And the what? Persons or things to be seized. Does it say arrest? No. Does it use the word arrest? No. You won't find the well, Professor Jackson, as I used to be called, I've been called a lot of things, and some of them are not so nice, but the things that were a little nice. So Professor Jackson or Colonel Jackson or Chief Jackson or just Ed Jackson, whatever title, you've been a policeman all your life. You talk about the Constitution. The Constitution doesn't mention the word arrest. What's the synonym for arrest? Detain? Seizure. Seizure. Everybody with me? You can only seize two things: people and property. That's the only two things you can seize: people and property. But what about an idea? That's intellectual property, right? For my lawyers in the house. People and property, right? That's the only two things you can seize. So again, I'll read it one more time. The right of the people to be secure in their persons. This is the amendment that's far more controversial than any. That's the most quoted amendment in the U.S. Constitution. That's why Baltimore Police Department went into consent decree. Baltimore Police Department now has entered into agreement with the United States Department of Justice, and they have 509 paragraphs. Each paragraph is a synonym or represents a reform. So in order to get out from under the authority of a federal judge, they have to satisfy 509 paragraphs. When I left the Baltimore Police Department, anybody want to guess how many they satisfied? Say that again, Will? Zero. After 3 years. So they still have 509 to go, last I heard. So, and they've been in consent decree for 3 years. So it shows you the gravity of, and most of it's centered around the Fourth Amendment. The Justice Department's investigation revealed that Baltimore had a history that dated back over a century of unconstitutional policing, and that minority groups have been most targeted. Not only minority groups, but minority groups more than other groups have been targeted for unconstitutional policing. It's been my experience in policing. Not only African Americans, but poor whites are subject to the same thing. Anybody want to theorize why that occurs? An opinion? Huh? Poverty. And what does poverty breed?
Lack of resources.
There you go. Lack of resources, right? Lack of an attorney, right? Or lack of adequate attorney. And public defenders are good lawyers, right? Kelly, what's the problem with public defenders? Stellar Group. They have a bad rap. And what do you see every day? By the way, Kelly Myers is one of my, and I see Corey, two of my students are here tonight, my former students. I know I'm embarrassing them. But what do you see every day, Kelly, that's problematic in Baltimore with the Office of the Public Defender?
I feel like a lot of the citizens in Baltimore City don't know their rights. They don't exercise the Fifth Amendment. That's what I see a lot of.
And what are the problems with the lawyers there?
Overworking underpaid.
Yes, they have huge caseloads.
Huge caseloads, exactly right. Huge caseloads, right? I hear people say, I want a real lawyer. I said public defenders are real lawyers. They have to pass the bar exam and get sworn in by the Court of Appeals here in Annapolis like all the other lawyers that practice law, right? The problem is that due to poverty, their caseload, right, Gene? Their caseload is more than they have the ability to handle properly. They can't give the care and attention to these individual cases as if they hired private attorney, right? And so my point being that even poor whites are subject to that. Not only African Americans, but we know that African Americans by far are far more impoverished in this country. And those are the kind of discussions that we have to have honestly. Yes, sir.
I want to throw one more variable in there, particularly dealing with Baltimore, and that's added to poverty, but even within that is housing laws, so policies, right?
Yes, sir.
Which disproportionately place people in harm's way because they end up having to be moved to areas that have fewer resources and fewer access to, attorneys and just the basic, commercial industry that spawns education for people to understand their environment. So I just wanted to throw in the housing piece because,
absolutely.
Which is, so we say poverty, but really when you look back at it, an aspect of it is actually the policies that put everyone in that situation.
Absolutely. And so when you talk about civil rights, they're contagions. They're contagions to some of these problems that we see. The police are often at the forefront of it, but why wouldn't you have some of the things you have? And I preach this. Will Rowell works out of the mayor's office. We've had some very intellectual discussions about some of the challenges that certain communities face. And it's not about stereotyping. I'm very careful how I choose our words, but in certain communities, when you have mental illness that's unaddressed, when you have schools that are inadequate, when you have drug addiction, alcoholism, we have all those social problems, mental illness, absentee parents, then if all those seeds of destruction are operating in the community at one time, then why would it make sense that you have peace and prosperity? Why would there be civic responsibility, right, when people are surviving? So when the seeds of destruction are planted, the harvest is going to be what? Destruction. It's like trying to plant apple seeds and expect them what? Oranges to grow. Mm-hmm.
I feel like the state's attorney's office in Baltimore City plays on that, the fact that the public defender's office does have such a huge caseload, and they put pressure on the clients and the public defenders for the clients to plead instead of exercising their right to appeal.
Excellent point, Kelly. Excellent point. They're under pressure, aren't they? And then here's what happens to Kelly's point. I've seen it happen with my own eyes as a policeman. Now, as a policeman, my client is the Baltimore Police Department. I'm using client very loosely, but I serve the Baltimore Police Department. When the state's attorney offers a plea agreement, poor defendants, quite honest, if they can stay out of prison, to them it's a win until they age out. Everybody know what I'm saying? Understand what I'm saying? Crime, you age out. You don't see too many hustlers 70 years of age, or or past 50, right? So when they're at the time of their life, when they're worried about their legacy, or when they reach 35, really, or 30, when they at the prime of their life, when they want to slow down and make a contribution to society, their record is so horrific that it takes them out of the process. Everybody understand what I'm saying? And so a lot of times defendants will plead guilty in court just to stay out of prison. A good friend of mine, a very dear friend of mine, is an attorney. He was a former Baltimore police, and he's now a defense attorney, and he would tell me horror stories how when your guys stand would get these guys on these murder charges, these guys would give them exorbitant amounts of money, cash, hustlers. All I got to do, I don't care if I get convicted. I need you to do what?
Keep me out of jail.
Keep me out of prison. Got too many what? Enemies there. Any sentence there is a death sentence, right? And so, but right away, it takes them away. They can't participate in a lot of things, right? And I think in Maryland, I don't think that's been changed totally yet. I think that we're moving towards that where convicted felons have full participation in the voting process. Many states don't. If you're a convicted felon, you can't even vote. You've been invariably relegated to a what? Second-class citizen in this country. That's another discussion. But now, here's what I want to say. We talked about Terry versus Ohio. Very important case to criminal justice. And Detective McFadden, who's been deceased now for about 20 years, he's a Cleveland police officer. And one day, he was in downtown Cleveland. He's working a pickpocket squad. He's a 39-year veteran of the Cleveland Police Department. And we went over the story. I demonstrated on stand. He's walking downtown, and Terry was the lead defendant in this Supreme Court decision. Like I said, before 1964, cops invariably needed a warrant to do everything because the Fourth Amendment says that the right of the people to be secure in their houses, papers, and effects against unreasonable searches and seizures shall not be violated. And it says, and no warrants, right, shall be issued. So what the Fourth Amendment was interpreted to say for the first 175 years of our nation's history is that for every arrest you needed to do it under the authority of what? A warrant. Everybody with me? That was the concept until this seminal case of Terry v. Ohio. Whatever a cop did, he or she, and it was mostly he's in those days, almost all he's in those days, had to get a warrant. So what the Supreme Court did, we elect these 9 justices, and we talked about the judiciary. We have 9 justices at any given time appointed by the president and confirmed by the Senate Judiciary Committee to interpret the Constitution for the times that we're living in. Everybody understand what I'm saying? In 1789, the weapons, firearms, consisted of pretty much muskets, right? And they had a rod, and they made these cannonballs, and they stuffed them. They didn't have semi-automatics. They didn't have banana clips and clips. They didn't have drive-by shooters in colonial days. Hell, they didn't have cars to drive by in. If they're going to do a drive-by, it had to be at a horse and carriage, and how far are you going to get away now? So the founders couldn't have imagined the times that we're living in, right? So those 9 justices, their sole job is to interpret the basic framework of the Constitution to render appellate court decisions to fit the times that we're living in. Does that make sense? And so what they invariably did with the Fourth Amendment, they lowered the standards to enable cops to make decisions independent of the judiciary and circumstances that were what? It begins with an E. Exigent circumstances, very good. Exigent circumstances. Everybody still with me? I'll repeat that. Before the Fourth Amendment, before 1964, cops invariably had to get a warrant for pretty much everything they did in the United States until the Supreme Court decided the case of Terry. It was Terry et al. It was 3 defendants. He was the lead defendant in that Cleveland, Ohio case. They had to lower the threshold because they said the times are changing. And we have to give police officers the ability through observation, through their experience, and through the time of day or night, their knowledge of the defendant, things that they couldn't have imagined in 1789 when the Constitution was ratified. They had to lower it, so they lowered it. And write this down. They lowered it from probable cause to reasonable articulable suspicion. They give cops reasonable articulable suspicion, meaning, as I said earlier, good reason, right? To first stop, and you can have a Terry stop without frisking, right? The Supreme Court says after about a half an hour, you better let him go, right, if you stop him. Because then what happens, Colonel?
It becomes a seizure.
It becomes a seizure. It becomes an arrest, right? Where you going? What you doing? Sit down. Shut up. Just those words alone makes it a what? a seizure because the person doesn't feel what? They're free to go, right? And if you don't have any good reason to do it, then you violated the what? Their Fifth Amendment right to unreasonable what? Seizure, right? Everybody still with me? So when you talk about, I'm sorry, I don't want to.
I'm chomping at the bit because this is the interesting part to me that I think is the rub for a lot of people, and that is the understanding that the reasonable part becomes subjective. It becomes at the discretion of the officer, which is power-based, right? And so when you're dealing with populations of people that have heretofore been preyed upon, or the assumption is everyone's going to have the wherewithal and understand and be able to articulate that position as well as you are, which I commend you for this. Because being able to have this discussion and know that you are totally knowledgeable of these things is incredibly important. But I think that's the rub part, even with the stop and frisk part, and why it resonates so much is because you have the perversion of what that means, right? Because it's left to the discretion. If you're down south in the Jim Crow era, that reasonable part can mean anything. It can, it's a spectrum of things it could mean. Like you were black, so it looked like you needed to be, you look guilty. So anyway, I just wanted to throw.
No. And I'm glad you said that, Will, because that captures the essence of why we're here tonight. That's the discussion part that we have to have, right? Because invariably, the Supreme Court gave cops that discretion. Hear what I'm saying? I'll repeat that. I think what you said was wonderful, and I think it's very important, and it adds a whole lot of credibility to the discussion. It depends on the officer, doesn't it? And it depends on the courts. And so basically therein lies the problem, right? I think it's a wonderful document. Is it a perfect one? Who did I say that to today? I said it to somebody. Is it a perfect one? I believe it's the pastor, right? We were having dinner. I said, is it a perfect one? No, because man wrote it. I think it's a wonderful document. I think it's one of the most impressive documents that's ever been written by any government anywhere, but it's not perfect. And for the reason you stated, that's the thing called discretion, right? It gives a lot of leeway, doesn't it? But then the courts also said, well, we'll give you that discretion based on reasonable articulable suspicion to later be what? Evaluated and judged by the courts. And if the courts determine that you didn't act reasonably, then what has to happen? The case has to be thrown out. And I agree with you, though. That's a whole nother discussion. And that's why I advocate for better training for cops in America. I advocate for better training. I think that we all should understand the Constitution, our civic organization, if they're going to better advocate for reform, because that discretion is not going to go away because specific special interests argue for it. It's a judicial process that has to occur. But excellent point. Yes, ma'am.
Picking up on what Will said, when you're talking about the discretion part and the case gets to court, you are to be heard by the jury of your peers. So that is the thing that's supposed to balance out. Now, if it's heard before a judge, you have, of course, the choice. But when you are heard by a judge by your peers, that should bring some sort of balance to that discretion part.
And it's supposed to be. Now, what's the problem with that? For every solution, and she's absolutely right, and this is coming from a lawyer and a former prosecutor. Now, in Jim Crow South during the 1960s, stay with me, there's been some jurors, right, who deliberated and determined innocence depending on the, and I quote, good old boy system in 10 minutes, right? It took them about, in the Emmett Till case, it took them about less than an hour and a half to find the defendant not guilty because the jurors of their peers were all wearing the same uniform. And y'all know the uniform I'm talking about. Wearing the same white uniform with the pointed cap and so you're right. I mean, jury nullification is another issue, and that's why it's healthy to have these conversations. But in a well-run jury, I would think the alderwoman would agree that it does balance it out if the jury is selected appropriately, doing voir dire, and voir dire is the term jury selection, and if it's properly vetted right, then it at least makes it exponentially more fair. Yes, ma'am.
I was going to bring up about the voir dire part of it. And that's where you get back to having sufficient legal counsel.
That's
so
right.
So it starts to balance and weigh itself out the way it's supposed to work.
That's
not
right.
all the time.
That's right, exactly. Good point. Yes, ma'am. And voir dire is a French word. This means jury selection. And so we talk about a jury of your peers. That's people who are reasonable, have the same level of education, similar life experience. If you're blue collar, I mean, a jury. What would happen if I charge somebody with burglary, and it's a police community? And we have those here, believe it or not, where all police live in a certain community. And voila, you go in there and you have 12 people who are in law enforcement. We'll make it realistic. Some are FBI agents. That's not a fair trial, is it? No. Because cops, we all know cops do what? Look out for cops. It must be true. If a cop said you did it, it must be true. And then what cop is going to say, hey, I voted against all those other cops? Can't we all get along? If life was only that simple, right? So I think that that was an excellent point, you know, and thank you, Alderwoman. She's the chair of our Public Safety Committee, and it's wonderful having her to work with and to work for. I work for everybody in this room because she understands. And when I posed the idea to her, I'm so glad you came tonight. I said, I'm going to go and take this show on the road. And it doesn't end tonight. We're going to talk about some other things, but you hit it on the head. Well, that's the problem. That's the challenge, isn't it? And that's what many civil rights organizations argue about this discretion that we give cops. One of the remedies is to make it up the ante for police service, right? Up the ante. You know, make sure that you choose men and women to serve who are part of the community. Start getting them to buy into law enforcement service. You don't wait till they're 21, right? You go out to the middle schools and you do community projects. I argue that we have shortchanged America by not addressing the social problems. You can blame me as the chief for a lot of things. You can't blame me because a guy comes home and he's frustrated because he's overworked and underpaid and he takes it out on his wife. You know what I mean? I mean, it's my job to respond to it and enforce the law, but I didn't cause that, right? Or Johnny goes to a party and experiments with drugs and now the parents can't control him, right? That's a family thing. That's a community thing. Or there's so much hopeless in the community that the only economy there is the drug trade. That's an economy, you know, and we don't want to face that reality. The drug trade is an economy, you know, and so until we start tackling those things and work collaboratively on those things, then and not make it the sole responsibility of law enforcement, we're going to keep spinning our wheels, aren't we?
Yeah, I'm going to add one other piece to that, and without the threat of getting in trouble. But a part of it also is political will.
Yeah.
And a part of it is also setting a tone for what we do want for where we live, right? And establishing that there's a general strategy to improve the lives of everyone who live in a specific area. And I do think, and that's why it's good, again, I commend you for doing this because it's good to communicate and educate, because the beginning and end doesn't start with the police department or the police chief. I believe that it's also the political will of policymakers and others to join in the exact same thing and set a tone for, like, you know, how we're going to approach these social issues. And it isn't just one, just like we won't blame the fire department if a pothole isn't filled. But what we tend to do is blame police departments and other departments for things that have absolutely nothing to do with the root causes of why we're experiencing it.
That's right, exactly right, and not train them to do it. Cops are not social workers. I don't apologize for saying that. If it shows up in the Gazette, yeah, I did say that, because they're not social workers. Most of our cops are willing to work with people who suffer from the disease of addiction. Lord knows we have a lot of programs to address that, to work with our partners, but it's not our sole responsibility. We are in schools now. We are doing some of those things to work with our other social agencies, our faith-based communities. That's an example right here now. That's why it was so important to start with the church, because the church is such an important anchor in any community, right? And so until we get into that, and that's what my idea was, is to start a movement whereby we empower the community through education. I'm going to give you some Supreme Court decisions that I want you to remember. And I don't know that I have the time to get into all of them, but we have, under the reasonable articulable suspicion. Is that less of a, true or false? Is it less of a standard than probable cause? True, right? True. It's not probable cause. You need probable cause under the Fourth Amendment to do what? Search or arrest. You have probable cause to search and you have probable cause to arrest. Let me give you a quick example and distinguish those two while we find that slide. You can apply for an affidavit, right? And I have a former prosecutor. An affidavit is a sworn statement, right? The Fourth Amendment says supported by what? Oath or affirmation. You have to stand, I do solemnly swear that the information that I'm about to give under penalties of perjury is true to the best of my knowledge and belief. That's the oath that the cops have to swear to. Or if it's testimonial evidence, Judy, you have to swear to it. I do solemnly swear. You want to see a cop sweat? If I had to do it tomorrow, I'll sweat. You do solemnly swear and affirm under penalties of perjury that the testimony that you're about to give is true to the best of your knowledge and belief. Tick tock, tick tock, tick tock. And those judges don't smile. Those men and women that wear those robes don't smile. They look at you. You got a decision to make while those balls of sweat are running off your head. My chief won't fire me, so I better say I do. I do. And then you have to get into why you did what you did, your probable cause. And then you have this defense attorney, objection, Your Honor, and then under cross-examination, they can tear you apart. It's a lot of pressure. And everybody should walk in the shoes in the life of a cop that goes through the entire process in one day. They used to do a commercial about that. And the guy said, I'll go back to being a stockbroker. Thank you, I appreciate it. Now, Supreme Court, Terry versus Ohio. Let me get back to that. I keep talking about that and keep getting away from it. That established reasonable articulable suspicion. I just want you to remember that. That's the seminal case law that established reasonable articulable suspicion. That's less than the standard of probable cause. Cops don't need, if they observe a certain behavior, pattern of behavior, the time and location, day or night, they have to be able to tell the story. Reasonable articulable suspicion is lengthy, isn't it? You can't write a short story. You have to say what drew you to that person and how it progressed. We even have mere suspicion. I can say, hey, how you doing? Where are you going? The person can say, none of your business, officer. Can I arrest them for that? No, that's their right. But we have something called the building blocks to probable cause. It goes from mere suspicion, right, Corey, to reasonable articulable suspicion to what? Probable cause. And when you're getting into probable cause, you're going to ask questions, accusatory questions, right? And then we're going to get into the Fifth Amendment real quick before I run out of time. But Terry versus Ohio, that's the seminal case that gave cops the ability to act without a warrant. Weeks versus U.S. Boy, I got to put my thinking cap on now. I think that was gambling. But the United States government, they gave the United States government, Weeks versus U.S., I think dealt with gambling. But let me move on to Curl. That's a good one. Curl versus U.S. And I got to do Tennessee versus Garden if I don't do any other ones. But Curl versus U.S. is another one. Anybody know what Curl versus U.S. is? Remember, any of my cops. Curl versus U.S.
Carroll Doctrine.
The Curl Doctrine, and elaborate there. That's another one of my attorneys.
Gives us a right to search based on exigency.
That's right, based on exigency. And what kind of begin from the M? The movable, right?
Yes.
It's a movable object, like an automobile, right? So that's the doctrine that says that if you don't act right now, the evidence can be what? Moved, lost, or destroyed, right? And so that's pretty much the Curl Doctrine. But the one I'm going to spend a little bit of time on, I think we did something. It's a very old case. It's one of the first suppression hearing cases in U.S. history. It's like a 1908 case. But Tennessee versus Gardner, that's a real interesting one. Tennessee versus Gardner was decided by the Supreme Court in 1964. And whenever an officer uses force, detains somebody for a lengthy period of time, even implies that they're not free to go. Under the Constitution, it's a what? It's a seizure, right? It's a seizure. Remember I said that the Constitution never mentions the word what? Arrest. So it's a synonym. You replace the word seizure with arrest, either property or people, right? So, in the Gardner case, two Memphis police officers get a call one night to a house. And when they get there, a woman says, a kid's breaking in next door. The officers go next door. One officer takes the front of the house. Another officer takes the rear. The officer in the front sees the kid with what he believes to be a radio or a TV or some object in his hand, taking it in a burglary. He tells the kid to halt. He fires a shot in the air, which was customary in the 1960s. And the kid still continued to run. And what happened, Miguel? He attempted to scale the fence, and what happened?
I think he shot him, didn't he?
He shot and killed him. He shot the 16-year-old kid by the name of Garner in the back of the head and killed him. What do you think happened to the police officers? Nothing. And why did nothing happen? Because at the time, police officers were allowed under common law, and I haven't even talked about common law versus codified law. Common law is that law that we brought from England, and it is based on the principle of stare decisis. It's judge-made law, it's case precedent, and generally the punishment was based on what the previous judge who heard a similar case decided. Everybody heard me. But then they took that power away from the judges, and our Congress and our state legislators started putting a law into code form. It's called codified law, put it into code form. And so back in 1964, I think that happened, or 1968 when that happened, during the due process revolution, the kid went to scale the fence. The officer said, halt, fired a warning shot, then pointed a gun, shot him in the back of the head and killed him. Tennessee versus Gardner, a lot of people who study criminal justice think it's a case about deadly force. And it has something to do with deadly force, but that's not at the core of what Tennessee versus Gardner was. What is the core of Tennessee versus Gardner, Sarge?
It's about the level of force for the crime occurring.
And the reasonableness of the seizure, right? And so here's how the court ruled, revolutionized policing, and this is something that benefited from the community. The United States Supreme Court ruled in the 1974 decision that the method that the Memphis police officers used to seize Gardner was what? Unreasonable. That because he didn't present a danger to the officer or anybody else, then the manner of seizure was unreasonable according to the Fourth Amendment. Everybody understood what I just said? And even though the officers shot and killed him, at the time, they were doing what? Acting within policy and the law of the state of Tennessee. I'll repeat that. It's important for you to know, at the time, now we're talking about over 50 years ago, if Gardner was alive, he'd be in his late 60s, early 70s now. He lost his life tragically, but those officers acted within the scope of state law. The Supreme Court says, wait a minute. He didn't, and the officers didn't lie. And that's what's so important about this case. And the officer raised his hand and swore under the penalties of perjury. He told exactly what happened. He admitted that he killed somebody that he knew was unarmed. But the law provided that any time you had a felon fleeing, deadly force was warranted under old common law. And at the time, the state of Tennessee still operated under old English common law. So the Supreme Court says no. And this very important case in Tennessee versus Gardner, the Supreme Court, again, the Warren Court, Chief Justice Earl Warren, the former governor of California, Stanford Law School graduate, says no. No, he handed down the majority opinion, almost overwhelmingly, that even though common law dictates that, that's not what our democracy is all about. You can only use deadly force against what? Fleeing felons of what?
Danger.
Say it again.
They're danger.
Of the dangerous type, right? Sergeant Miguel, you can only do it, kill people if they present a danger to the community or yourself. There's a whole lot of felonies, isn't it? I lied on my taxes and embezzled some money from the federal government, and I wear a suit and a tie, a Brooks Brothers suit and a white shirt, and I have an MBA from Harvard, but I'm charged with felony tax evasion. And the U.S. Marshals go to serve the warrant on me. I never held a gun in my hand in my life, but I start fleeing. And then under old English common law, I could do what? I could shoot and kill this guy, right? So the Supreme Court says no. So you can only use deadly force if they're fleeing felons of what? The dangerous type. And so I remember when the decision, the event happened in 1974, I'm sorry. Terry was killed by the police in 1974. The decision was handed down in 1985. And let me tell you a true story. The Supreme Court says with all deliberate speed, they set an order, the United States Supreme Court, for every law enforcement agency in the country. You may remember this, Alderwoman Pendell Charles. Every prosecutor, every law enforcement police department in the United States had to read what that Supreme Court decision was. We had to sign, literally sign, saying that we understood that we can't pull out that weapon and take the life and seize a person who had committed a felon that wasn't of what? The dangerous type. Everybody with me? And so that case was more about the reasonableness of the seizure than the actual deadly force. The story behind it is very sad, because a 16-year-old who had committed a burglary lost his life based on the laws of the state of Tennessee at the time. But under the Fourth Amendment in Tennessee v. Garner, it said that the seizure was unreasonable. So if you haven't heard anything else I said tonight, those are the kind of things I want you to understand. I want you to understand that when you see an officer approach somebody and they're frisking them, frisking in and of itself, and I repeat this, and please understand me, frisking in and of itself, stop and frisk, if it's done according to the highest source of American law, if it's done appropriately, it hasn't violated anything. It's the misapplication of stop and frisk is the problem. If I put out a memo as Chief Jackson saying, I want all black males in Annapolis stop. Shootings, we had shootings that occurred this weekend, and every black male that you see on the street, I want you to stop. Every Latino male you see, I want you to stop. Every white male that's wearing blue jeans and a sweatshirt, I want you to stop. Now I'm doing what? Profiling people. I have no legal reason to do what? Stop them. That part of it's wrong. Mm-hmm.
So dangerous. So there's a part in there, the dangerous type, or what was I know I'm going to sound.
The fleeing felon of the dangerous type is the exact wording.
So of the dangerous type, how is that defined? Like, how do you? Because again, and excuse me, because I am an African American man, I feel like that's the part that, like, so what is that? How do you? So how does?
I'll give you an example.
Right.
Well, I'll give a real example that happens all the time. It's happened years ago, and it happens to this day. You ride down the street, you turn the corner, two guys are beefing. The guy shoots a guy in your presence. You're an officer, you're a sworn officer, you're on duty. This really happens. Pulls out the gun, pow, 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 pow. He turns around, he fires a shot at you, pow, but he misses you. You get on the air, and you call a signal 13, that means officer needs assistance. That is really bad, and the lights and siren are coming. This guy's running. He's running up and down Spar. He goes down, I don't know, he goes, we see him running on West Street, we see him running everywhere. And then he takes a woman, and he closes on her, he grabs the woman by the neck and says, if you come on, and old lady by the neck, and he says, you better get away, back off, officer, I'm a killer, right? He's already shot one guy in the stomach, already shot at police, right? Under that, is he a fleeing felon of the dangerous type? Yes. And so the Supreme Court says that's when deadly force is appropriate, right? You don't want to wait for him to kill somebody, right? What if he drops the gun and he runs? And he's no longer what? Of the dangerous type. But then some can argue, well, you can add to the scenario, he may have a gun in his ankle, right? He may have a machete, who knows? But I just gave you the most obvious one that really occurs in the streets of America. So if he doesn't stop, he's considered a fleeing felon of the dangerous type because he's already demonstrated he's what? Willing to use deadly force by shooting the person in the stomach. Then he shot at the police. Then he grabbed, if I'm repeating the scenario correctly, I said he put his arm around it and held somebody temporary hostage. The police said, okay, we don't want no trouble. They back off. He drops her and continues to run. What else is he going to do? Right. And if he's really cornered, what is he going to do? So if the officer has a clear shot at him and he refuses to surrender the weapon, he's already previously demonstrated, and that's how the officer would have to write his report. That's how we have to articulate it, right, Deputy Chief Herman? He would have to actually go through all the methodology. He has to tell the story properly. The problem in America is that we don't teach our officers to hone in on their report writing skills properly. That's another thing I'm going to talk about, the importance of writing a good report. Yes, ma'am.
Hi.
How you doing?
Before I challenge and ask you a question, I just want to talk a little bit about my credentials and the perspective that I'm coming from. So I'm a social worker, and I work as a mental health clinician. So I've been taught to look at things from a very behavioral health perspective and through the history of behavior and socialization and things like that. And so first and foremost, I want to say that I am absolutely against stop and frisk in any way, shape, or form. And I absolutely challenge the notion that stop and frisk as a tool to be used by law enforcement can ever be used correctly in accordance with the Constitution. And I'm going to tell you why. So first of all, if you look at, I don't know, and I came in last minute because I had to be at another meeting, but if you look at the history of law enforcement in general in this country, And when you look at how law enforcement has generationally and for years and years and years have been trained to police, one thing we cannot deny is that from the very beginning, law enforcement has been trained to police with racial bias and racial implications and through racial profiling. Not only have they been trained this way, but we also know that within society, there's this thing called racial socialization. And racial socialization means that white people are racially socialized in one way, black people are racially socialized in another way. But when we think about the images of blackness, we have all, including white, black, brown, Latino, been racially socialized to see being black as dangerous and violent and aggressive and everything that we just mentioned. Another thing that I am going to challenge you on is the fact that when we look at research and we look at how to even show and prove whether or not racial bias or racial profiling exists within a police department in the way one polices, it is a very subjective thing. There has been not many or much, as far as I know, objective ways to determine whether or not a person has used racial bias or not used racial bias when they are policing, right or wrong. So I'm trying to understand when we have all been racially socialized, and this is not nothing new, and that historically we know that law enforcement has been taught and trained to use racial bias and racial profiling in their policing. In the city of Annapolis in general, there has been multiple lawsuits, there is multiple documentation that show that Annapolis has historically used racial bias and racial profiling. I would like to know how you are all of a sudden going to unwrite those things, find a way to appropriately measure and determine whether or not racial profiling or racial bias exists within your police department, because it exists within all of us as a people. That's human behavior. And how you plan to not have the black and brown community when simply driving through a neighborhood. I have seen in Eastport where there is a police car that is facing this way with white Annapolis behind it and black Annapolis in front of it, which sends huge internal messages and subliminal messages that say, we're looking at what you're doing and we have the back of the white community. So I want you to explain how they can be done and done effectively. I need you to give me research on how stop and frisk has ever been effectively used in accordance to the Constitution. And I want you to tell me how you plan to do that here in Annapolis. Because we are not going, the black and brown community is not going to sit back and allow stop and frisk to be used when historically the black and brown communities here in Annapolis has always been over-policed. And stop and frisk has many research studies to show that, number one, it's not really all that effective, because all you're doing is locking up black and brown people into a system that is for recidivism, which means they're gonna come back out of prison even more traumatized before they even went into prison, and so they're not gonna come back with the tools necessary to be a citizen and contribute to society. How are you gonna make all of that happen while protecting the black and brown lives of this city?
Well, you just got here, and you said a lot. I'm trying to take it all in. I thank you for your comments. First of all, the whole crux of this tonight is to talk about the Constitution and its structure. You or the organization that you represent or social work is not going to change what was established by our United States Constitution. That would require legislative change. What I expressed tonight to the community is talking about the preambles, the articles and amendments, and the authority that was handed down by the United States Supreme Court particularly, not even our U.S. Congress. So when you ask me about research and what am I going to do about some of the social ills, my job at the core, what I did first of all, is to provide public safety. And that's to provide public safety.
I didn't ask about the social ills. I asked, how are you going to implement a policy that was already doomed unconstitutional? The way that it was being used, it was doomed unconstitutional. Wait a minute. And I asked you, how can you ensure that the police department here in Annapolis does not use racial bias and racial profiling when that is very subjective and it's been done in the police department historically?
Stop and frisk?
No, the way that you apprehend who you're going to apprehend for stop and frisk. It's subjective.
No.
Yes.
No, not in the context in which I'm speaking. I've said over and over again to community groups. And to be honest with you, I'm standing firm on what I'm saying. As in case you don't notice, I'm a black man. And so I understand everything that you're saying. Well, maybe not to you, it does to me. That's who I am. But I'm not even going to get into that with you. But what I am saying is that we're here tonight to talk about the Constitution. You know, I can't control what you or your group says. You're entitled to your opinion. I'm here to, no, you didn't give me facts.
Okay.
You gave me your opinion.
research.
You gave me
No,
your opinion.
no.
You haven't shown me any research. But you stated, well, wait a minute, we'll talk about that. Wait, let me ask you a question.
This right here is a lawsuit against the city of Annapolis that showed racial bias, not only just racial bias.
But that's not what I'm
Here is a
talking
lawsuit
about. That's
that
not what I'm
showed-
talking about, man. We went
Police
over the
brutality.
Fourth
Oh, I had
Amendment
facts.
to the U.S. Constitution.
Okay.
And I believe if I read your blog, you said that the lower court, the U.S. District Court for the state of New York ruled that stop and frisk was unconstitutional.
Yeah.
And let me educate you a little bit. A subordinate court can't rule that a superior court's decision is unconstitutional. What I said was stop and frisk, if it's used appropriately in compliance with the United States Constitution, is a tool that the United States Supreme Court says that law enforcement can use. It's in the Supreme Court decision handed down in 1968 in the case of Terry versus Ohio. Now, when you talk about racial profiling, I don't doubt that that doesn't exist. We talked about that
Your mayor said it
tonight.
doesn't exist.
No, I didn't say it didn't exist.
Your mayor said it and supported you and the Capital newspaper. He said that there's no.
Well, that's what they said. I'm here to tell you tonight that that's not the case.
Okay.
What I am telling you is that Michael Bloomberg, whether he did it or not, I don't know, he was accused, the mayor of New York was accused of using the Supreme Court decision, using the practice of stop and frisk. He abused it by targeting African American males through policy. I'm not talking about a policy. Since I've been the police chief, which is since I was sworn in on July 31st, 2019, I'm a former college professor. I never once said that we were going to use stop and frisk to target anybody. I said we're going to use it in compliance with the United States Constitution. What happened in New York is different from what I'm saying. It's like using medicine. You can take a bottle of medicine that could cure my ills, but if it's abused by somebody else, it could kill them. Stop and frisk is the same thing. If it's used to target somebody who really poses a threat to public safety, I don't care what community it's in, right? Baltimore is experiencing an unacceptable rate of homicide, very high. When you call the police, you expect them to do something. If a police has reasonable articulable suspicion to believe that a person is illegally armed, not Ed Jackson, not Chief Jackson, not Chief Altamari, not the Commissioner of New York or Philadelphia or anywhere else said that stop and frisk will be used as a policy. The Supreme Court says it's appropriate. And so what went on in New York versus what I'm saying are two different things. I haven't enacted a policy. I'm telling my officers that if they have good, reasonable, articulable suspicion in compliance with the standards set forth in the United States Constitution, they are allowed to legally use stop and frisk. I didn't tell them to go out and target all black men walking down the street or all African American women or Latino men and women. So you gave me, your question was loaded. And I don't think we have, yes. Well, I'm sorry, that's the best way. That's why I'm here tonight. Not to, you gave me a manifesto. We can talk about that later. I'll gladly sit down and talk to you, but not in this forum. Because what you're asking is really off the subject. You're here to challenge the veracity of stop and frisk. And I'm here to tell you, standing firm, that what you're talking about versus what I'm lecturing on tonight are entirely two different things.
Thank you for your.
You're welcome. Thank you. Thank you. Any other questions? I know my time is running down. Yes, ma'am.
Yes, I just would like to hear what is happening now as your chief about the bias that police officers and we all, as this woman talked about, we all are socialized with. So what are solutions to policing to deal with bias so they don't?
Yes, ma'am. I agree. And here's the thing. Here's the thing. And I'll give you a chance, Corey. Here's the thing. We all have biases. I would admit that. Every human being. You wouldn't be human if you didn't have a bias. That's why we have so many different philosophical thoughts. Heck, our churches are divided into denominations because one group feels that another group, that's why we have the Protestant church versus the Catholic church, and in various denominations therein. There's biases everywhere. You're never going to get rid of that. And as long as cops are human, you're going to have biases. What you want to do is minimize it and make sure that your agency has a culture and a structure that minimizes that. And then once we find people who are acting in a biased way, then we take the proper administrative procedures to make sure that kind of conduct is rooted out. But it's unfair to sit here and throw these darts at the police chief or anybody else to say that what are you going to do to rid out bias? That's like asking me to be Tinkerbell. A whole lot of social systems in place. Not only is there criminal justice, there's economic justice, there's social justice, there's a whole lot of other justice. But the problem is that police are the first line. I'm not here to say that police have never engaged in misconduct. That'd be silly for me to say. We all know the stories. We all know what happened to Eric Gardner. We know what happened to Trayvon Martin. We know what happened to the young man in Minnesota, and we know what happened to Freddie Gray. So I'm not here to argue those merits. What I'm here to talk about is the Constitution and its purest form. This didn't come from Mayor Michael Bloomberg. Stop and frisk did not come from Mayor Bloomberg. It was handed down by the Warren Court to say that an officer with reasonable articulable suspicion has the authority vested in him by the United States Supreme Court. Like we went over earlier tonight, we have 4 sources of American law. That's it. The highest being the Constitution. It's not stop and frisk that's the problem. It's the application of it that has become the problem. I would agree with you that if you target a specific race of people or a specific ethnicity, then we're wrong. But to say that should be thrown out, first of all, no police in America can throw out a Supreme Court decision. So let's be real about this. You can advocate and agitate and talk all you want. This is an intellectual exercise to do 2 things, accomplish 2 things. Let the community know what their rights are under the Constitution and their privileges, and to demystify some of the practices. We can go on and on about misconduct, and that's unfortunate. Every profession has misconduct, right? A mayor was just sentenced to 3 years in prison today, and that's not about her, but there's misconduct everywhere. A doctor just lost his license in Maryland a couple of weeks ago. So every profession has its misconduct. And so the problem is, and the reason why we're going to do these talks, is that we have a lot of social problems, as I stated earlier, that has gone addressed. And then American citizens, in many ways, I would agree, have a right to be enraged, but it goes beyond just law enforcement. I'm sorry, Corey, I'll get you, sir, but he had his hand up first. You want to say something, Corey?
Yeah,
You've been patient.
So I'm a black male that grew up in Baltimore City, right? And I wasn't exposed to all the education, these institutions until I got, 18 or something. And that was after I was incarcerated. I didn't really know too much about my rights. And as I began to progress throughout the years, education-wise, I began to educate myself. And once I understood the education, I understood that it takes the community to actually police itself. There's not going to be policies or regulations that's going to say, you know what, this is what we're going to do. It's not going to come from a police chief. It's not going to come from a police officer. It's all about the community and what they're going to say. It's about their opinion, their policy that they're going to create for their community. And that's how it was back in the old days, when you had older people that dictate certain things that say, you know what, hey, you can't do that. But it doesn't exist anymore.
Doesn't exist. Can you stand up for a minute, Corey? And I'll get to you, sir, in a minute. This is Corey Millington, and it's hard for me not to get emotional, just like with Kelly. They were my 2 students, but he didn't tell you. All those things are true. Well, Corey has a master's degree now from Towson,
Coppin State,
and University of Baltimore. He holds his master's degree. He was commissioned as a 2nd lieutenant in the National Guard. And so, when you engage young people in Baltimore City the right way, this is the end product. He holds a master's degree now, and he's a 2nd lieutenant. And he's one of the guys he was one of the bodyguards. He sent me a picture, and I still have the picture on my iPhone. He's standing in front of then Vice President Joe Biden and said, "Look, Professor," and he was you all were providing security for him. I don't mean to get off the subject, but I just wanted the audience to know the power of appropriately engaging young men. I tell Corey all the time in our phone conversations, America's not so evil, is it, Corey? Now that you have a master's degree and you have options in your life, right? No. And that's a little running joke that we have. I used to call him the angry guy. He was a big, tall, strong guy. And, but he came to Baltimore City Community College looking for an opportunity. He stayed the course, and I'm so proud of you. So I just want to say that that's a sidebar to all of this. I'm sorry, did you finish your point?
Yeah.
But I agree, and I said this earlier, that until we get more faith-based in our communities, you know, our educational systems are strengthened, right? Until we get those three things and our families are strengthened, we're going to have too much police courts and corrections. I'll be the first one, man, to say we have too much police courts and corrections in our communities. But then, where are the other institutions of social control, right? And so,
can I include on that? You know, like I've been a part of so many different organizations. As you know, I'm a Freemason as well. But the organizations that are set in the community are so divided that everybody's competing. I'm trying to be the best black organization. I don't care if it's the Divine Nine, I don't care if it's a social fellowship, I don't care what it is. Everybody's competing, where they're so divided where they can't make a proper decision. And that's when you get this whole haymaker that everybody's trying to dominate and they don't see the cause of the people.
Yeah, I would agree with that, but
I know I'm running out of time. I'm sorry.
I'll make it. So I wanted to, I will say.
And I really got to get to you. Okay.
And I will say that, that like we're in the grown zone. So the grown zone is, and this refers to statements that have been made, and actually the reality of the tension that exists. And the grown zone is that zone between divergent thinking and divergent opinions. And in this city, when we're honest, it's an honest thing. And the honesty is saying all of those issues, whether it be housing, whether it be blatant discrimination, whether it be policies that are discriminatory, they're coming to a head. But I will say this to let the air out a little bit of this, is that the 5 years ago, we would not be having this conversation with the police chief and with citizens. And I think the power in it is being able to move from this grown zone where we're grumbling and fighting, but really listening and hearing each other and considering what people are saying, to have convergent thinking. So out of the divergent and the grown is the convergent thinking. And I think when all of us look at it that way, that these are meaningful questions and conversations, just as what you're posing with the Constitution. And I'll get back to my piece. The piece is also, to your point, but also not just the community will, but also having the political will. Because we have to set the tone, but we have to be very real about where we've gone in this nation and the fact that this is an original colony. Yes. And that a lot of what exists here, when we're honest about it, stems from slavery, and it stems from suppression and whatever else. But that doesn't mean we can't change it, but we have to be able to have those honest conversations. That doesn't mean it's your fault. So I think the other piece is remembering we just have to be mindful. And I do think sitting down and really having some conversations about where we go from here and just being mindful that we are paying attention to those marginalized communities. Because today, I mean, it is about power. Yes. And the truth of the matter is, in this city, we have a mass unbalanced distribution of power. And that being said, like, that's the reality of where we are, which is horrible, but it's a reality. You know, so we have to get to some convergence.
And I know you have, but let me make myself very clear. You're not my enemy, and I'm not yours. I'm here to fight on behalf of the people who need advocating for. And when you create an environment that is a breeding ground for crime, and it's been created by the very people in power. I mean, I want you to pay attention to what is going on in Annapolis right now. There is mold-infested homes. People who, you want to talk about the crime, there are people who live in these very communities who have lost their sons, who have lost their children, and they're in this environment where they've been isolated, black and brown people, because the majority of the people who are in these communities are black and brown, that has been isolated because they are impoverished into these pockets of housing where they have no resources, they have no hope, and they're growing up in a survival mentality. Some of them don't even think that they're going to live past 19 years old. So instead of saying, let me see what I can do to make life better for you, I hear, let's stop and frisk. I'm not okay with that. And I get from a law standpoint, and I get from a constitution standpoint, but let's be real. This is the exact same constitution that has passed what is called the 13th Amendment, that has done nothing but transform the words of slavery to say that there is no slavery unless you commit a crime. Hold on, wait a minute. Unless you commit a crime. And then today in 2020, there are more black and brown people who are massively incarcerated that get free labor in these private prison systems that make a whole ton of money than there ever was in slavery. So when are we gonna have a collaborative conversation like what he just said and say, okay, behavioral health people, law enforcement people, we come together to make a common solution. Because what's not gonna be okay is the police against the community. And that's how it has always
Man,
been.
listen up. You got here late. We talked about that as a collective group way before you got here. You came in on the tail end of this. I started out my presentation tonight, and I said very clearly that a lot of what we wrestle against the social problems has gone unaddressed. But in all fairness to me, play the video back. You weren't here to hear about that. Wait a minute, ma'am. And so, no, I said only in the context that the Constitution says that we can use it. I didn't say my whole agenda as the police chief of Annapolis is based on stop and frisk. That's where you're wrong. But no. That's the language is from the Supreme Court, ma'am. Well, we're going to end today. I'll talk to you later, and I want to give you a chance. So I know y'all came together, but I'll give you a chance to speak.
So Devon Brown here, and you're very charismatic, I must say. You have a way of almost like a preacher. So I commend you for being able to do that. But I think what the whole problem of it is, because I see both sides, but the main point is just the words, and I know I came in late as well, and I'm sure that we talked about police, community policing and building a relationship with the community, but I just think that using that word creates division from young African American males who already do not trust the system. And so because they don't trust the system, I understand how you're saying it in the Constitution, but you, as an African American police chief, should understand that words matter. And so because words matter, I'm not saying that you're saying that you're going to do this, and you've explained it well. You explain what it is that you're trying to do. But it's just the word that you use that already scares people, particularly the ones who it targets. So I think instead of using that word, we may have to come up with a better phrase to
that's to say that the Supreme Court is wrong. I understand what you're saying. Stay with me. Don't get angry with me. But first of all, let's be fair. I was asked the question. Let's go back. Let's reel this whole thing back. I didn't come in with the stop and frisk agenda. That's the first thing that we ought to make perfectly clear. When I went into the Eastport Civic Association meeting last Monday with the mayor, the alderwoman, a couple of alder people, it was a nicely attended meeting. I didn't bring that up. I was asked to come there to address the violence in Harbor House, me and my staff. Once I got there, when it came to my portion of the program, I was asked the question, how do you feel, Chief, about stop and frisk? My reply was that stop and frisk is a decision handed down by the Supreme Court. Even the word stop and frisk comes from the United States, it comes from case law, the case law of Terry v. Ohio. They weren't my words. It's a process if used appropriately. And if you go back and look at the video, I even said that when we had 5 journalists who lost their lives. Wait a minute, hear me out. Over 2 years ago, I said the defendant and the suspect who later became the defendant was a white male. Stop and frisk would have been appropriate in his case. I said as long as it's equally applied against anybody who police officers have good reason to believe poses an immediate threat to anybody, then I have no problem with it as a part of police procedure. What are we to do if we go into communities? You can't have it both ways. You can't call the police and ask what are we doing about violence if we see people who are wantonly walking around armed with the sole purpose of hurting people, even hurting black and brown people, hurting each other. So all I said, sir, was if it's used in the right context. Now, it's not my job. I am the police chief to all Annapolitans. I don't have a black agenda or a white agenda or a brown agenda. I took an oath to protect every person who comes to the city of Annapolis. Everybody in this room are U.S. citizens. And I shouldn't be the police chief if I'm to stand up here. But you described a lot of social problems, and we let other social organizations off the hook. We have all these I'm going to get myself in trouble now. We have all these mega churches in some of the most highly, the most criminal neighborhoods in Baltimore City. I don't hear leaders talk about that. I can walk, I'm born and raised in Baltimore, and some of the most problematic areas in Baltimore City have mega churches and absence of schools and liquor stores and all these other seeds of destruction that are readily available to people. But we don't talk about that narrative. And if we're ever going to get past this, all I'm saying to you tonight is that the police are not the only problem. And I can't, sir, in good conscience, confuse my men and women. I can't send them out there and tell them to be tentative when they are confronted by somebody who poses an immediate threat to either themselves or anybody in the community, regardless of the color of their skin. I'm not going to be a part of that because that's not why I took this job to be the Annapolis Police Chief. I'm a public safety professional, and I'm sorry if I offend. My intention not to offend anybody. My intention is to make the most safe environments for everybody, regardless of who you are, regardless of your religion. I don't care if you're Islamic, whether you're Christian, whether you're Jew. I don't care. If you come into Annapolis, it's my job as the chief of police to make sure that your experience here, whether you live here or you're coming here to visit, is the best experience and the safe experience, the safest experience that you can have in any American city. Yes, sir.
I think that both of you need to offer an apology. This is not a town hall meeting. This was a history presentation of what the Constitution has said.
It went off that.
I am a minister. I work in a low-income community. I think it stems from mental health, faith-based, the school, and the community. I am the only pastor in this neighborhood. So why aren't there other ministers rallying to help this single mom with 6 kids by 4 different men? The 15-year-old is sleeping with someone down the street, selling pot. So why aren't you advocating for more social workers in these communities to help to nourish these communities and to bring them to the forefront and make them decent citizens? I think it was very rude to interrupt such a gathering, which was a historical presentation, and make it a political presentation. That's where you should have been at the Eastport gathering, and at the other gathering where we talk about gun violence and mental health in our communities.
Can I?
Don't even respond.
No, because like I actually had my hand up.
Well, wait a minute, and I don't want to cut anybody short. I didn't get to the Fifth Amendment and the 14th Amendment. I'll just say this real quick. The Fifth Amendment deals with due process of law. You have an absolute right to remain silent, that the government used the term bill of attainder. That means that if you're charged with any crime, you have a right to due process. That means even guilty people people who we deem to be guilty or bad people have rights. That's the premise of the 5th and 14th Amendment. Even bad people have rights. And so if we're going to have a true democracy, then we're going to have to understand these concepts. I'm sorry I ran out of time, but I don't want to overstay our time because the church has been so gracious. I'm going to thank you again. I want to continue these discussions. And I don't get angry from my dissenters, but we have to look at the context of which this forum was about tonight. This forum was totally about the law, about the highest form of law in the land. And I'm only saying this not to be right, but the particularity clause is the particularity clause. The Supreme Court decision in Terry versus Ohio is Terry versus Ohio. You can advocate about oppression, historical oppression, slavery, Jim Crow. I agree with all of those things. I agree that we still suffer from the legacy of all of those things, and we have yet to resolve those issues in America. But this wasn't the forum tonight. This forum was to empower the community to understand the Constitution so that they can make informed decisions that can challenge us to stay the course and do what we were duty-bound to do in accordance with the Constitution, get all our authority under the 4th Amendment. So this was in no way, shape, or form to be designed along partisan politics. This is not a Republican agenda. This is not a Democratic agenda. It's not even an independent agenda. I'm a police chief who's been given the honor, the highest honor of my professional career, to be the police chief of the city of Annapolis. And when I walk down the street, I want all Annapolitans to look at me and say, that's my police chief. I don't care if you're white, you're black, you're Asian, you're Latino, you're Arab, you're Native American. If you're a citizen coming through here, or if you're an Annapolitan who was born and raised and live here, I want you to see me as your police chief. And I hate to cut this short, but I'll give you the last word, Corey, because I don't want to cut you off, and then I think we have to end.
And I totally understand what he's saying, right? The stop and frisk thing, it is associated with, discrimination, whatever he may want to call it, because I understand what he's talking about. But, I mean, you talk about changing the word, right? What do you want to change that word to? Because if I was somebody out on the street, I don't care what their name is called.
Right.
If you're stopping me and you're patting me down, I'm gonna feel,
I agree
I'm
with you.
automatically going to be
I agree
offended.
with you on that.
I'm gonna be offended regardless. I mean, especially if there's no real suspicion, and it's up. That's what he was trying to tell you. And I get what she's saying too, because it's up to the discretion of the officer. So that totally goes out of his hand, out of the next person's hand. So I mean, like, to re-amend that, is there a set? Are you talking about creating a set policy for that stop and frisk, or just eliminate it and abolish it?
I feel like it should be eliminated.
No,
period.
no, I don't, so my.
But I mean, that's a political agenda that needs to be pushed for the community.
Okay, I have to say, we can talk about this.
But I'm not running for office. I don't have any political agenda. I am a person who cares about human life. And this is a conversation that needs to happen. It's an educational conversation that needs to happen, because you're saying that.
That was the meeting last week. So now, I hear what y'all saying, but I think it's getting out of hand. The purpose of what he did was just to talk about the Constitution.
Pastor Dave Vorbeck, we'd like to thank you again. By the way, the last thing I'll say is that we have a list of things that we're going to talk about, subjects throughout the city of Annapolis. We're going to change venues, and they will be posted on the website. Sergeant Amy Miguez has already established the dates. We're going to have topics. We're going to talk about a whole lot of other topics related to police and the community in the near future. So everybody, and I would love for you to come out and we can have a discussion beyond this at some future date, but tonight this was all about explaining the Constitution. I didn't get through everything, but what we'll do is we can sit back down at the table, and if we want to continue this, I can put some feelers out there and we can finish the rest of it. I didn't get to the amendments, but I got through, I think, the basic part of it that I went to. So I hope you enjoyed it. It was a labor of love. I want to thank each and every one of you for coming out. Again, it's an honor to be your police chief, and I hope we will do what Mayor Gavin Buckley said, work towards one Annapolis, and that's the agenda. Thank you so much. Everybody have a great evening.